Before I begin, I would like us to take a moment of silence in honor of Dwight Wright, George Floyd, Breonna Taylor, Ahmaud Arbery, and all whom we have lost to COVID-19 and police brutality. The dehumanization and criminalization and vilification of Black and Brown bodies must come to an end. And our hearts, thoughts, and prayers are with their families and all who have been affected by these senseless murders in COVID-19. So let's take a moment of silence. Thank you. Last year, we joined forces to share insight on how the Title IX regulations under former Secretary Betsy DeVos rolled back protections for students and survivors, especially during COVID-19 pandemic and the heightened awareness around systemic racism and other forms of oppression. Now we come back to you with a little bit better news on the future of Title IX. Last week, the Department of Education's Office of Civil Rights announced their launch to conduct a comprehensive review of the Title IX regulations per President Biden's executive order on guaranteeing an educational environment free from discrimination on the basis of sex, including sexual orientation or gender identity, which was signed on March 8th. Under the executive order, within the next 100 days, the Secretary of Education, Miguel Cardona, in consultation with the Attorney General, shall review all existing regulations, orders, guidance documents, policies, and other similar agency actions. So to give you a rundown of what to expect during Title IX, first we're going to hear from Valerie and her thoughts about the Department of Education's review of Title IX regulations. Then we'll hear from Tracy, who will provide you with an overview of Title IX and dive deeper into what those regulations mean for survivors and campus administrators. And I will provide you with a rundown of what we have coming down the pipeline with regard to our calls to action. So before I introduce Valerie, I also want to say to everyone who's joining with us, whether it's via Zoom or via Facebook Live, that while what we have to share with you is of great and hopeful news, we also know that Title IX regulations and processes around it have, on a whole, have been triggersome, especially for the past 4 years and beyond. And so at any point throughout the town hall, if you feel that you need to step away, please do not hesitate to do that. And if anyone or someone you know needs immediate support, we can provide you with some hotlines that are still open and available for you during this time, which we'll place in the chat. Additionally, we understand that some of you may want to share your story towards the end of the call. And if you do that, we do ask that you share stories with us directly as hosts of the call or after the call, where you can email us at erock@civicnation.org or contact@itsonus.org. The point of this call is really to share information on Title IX regulations and ask you to join us in further action, this time with the Department of Education, to ensure that your voice is being heard. We don't want to cause anyone to be triggered by another and further perpetuating harm. So we thank you for your presence and we thank you for being here. Now, to continue on with our program, I'd like to introduce you to our guest speaker. Valerie B. Jarrett is a Senior Distinguished Fellow at the University of Chicago Law School and the President of the Obama Foundation and attorney. She serves as the Chairwoman of the Board for Civic Nation. She also serves on the board of Ariel Investments, 2U, Lyft, the Innocence Project, the Economic Club of Chicago, and the John F. Kennedy Center for Performing Arts. Her New York Times bestseller memoir, Finding My Voice, My Journey to the West Wing and the Path Forward, was published in 2019. Ms. Jarrett was the longest serving senior advisor to President Obama. She oversaw the offices of public engagement and intergovernmental affairs and chaired the White House Council on Women and Girls. Ms. Jarrett worked throughout her tenure at the White House to mobilize elected officials, business and community leaders, and diverse groups of advocates. She led the Obama administration's efforts to expand and strengthen access to the middle class, boost American businesses and our economy. She championed the creation of equality and opportunity for all Americans and economically and politically empowering women in the United States and around the world. She oversaw the administration's advocacy for workplace policies that empower working families, including equal pay, raising the minimum wage, paid leave, paid sick days, workplace flexibility, and affordable child care, and led the campaigns to reform our criminal justice system, end sexual assault, and reduce gun violence. Ms. Jarrett has a background in both the public and private sectors. She served as the Chief Executive Officer of the Habitat Company in Chicago, Chairwoman of the Chicago Transit Board, Commissioner of Planning and Development, and the Deputy Chief of Staff for Chicago Mayor Richard M. Daley. She also served as the director of numerous corporate and not-for-profit boards, including Chairwoman and Chief Executive Officer of Chicago Stock Exchange, Chairwoman of the University of Chicago Medical Center for Board of Trustees, and Director of the Federal Reserve of Chicago. Ms. Jarrett practiced law for 10 years in both the private and public sectors and has also received numerous awards and honorary degrees, including Time's 100 Most Influential Women, as well as the Abner J. Makda Legal Legends Award. Ms. Jarrett received her BA from Stanford University in 1978 and her JD from the University of Michigan Law School in 1981. With that, I'd like to please welcome Ms. Jarrett.
Thank you so much, Kenyora, for that introduction. You could have left off the years I graduated from school, but everything else was just perfect. Hello, everyone. I am delighted to be here with you today. I'm hoping that you and your families are safe in the midst of this global pandemic that has lasted well over a year and taken far too many lives. If any of you have lost loved ones or struggled yourselves, I'm thinking of you. And Kenyora, thank you for that very powerful moment of silence. It has been a tough year for so many of us. But it is good to be with you today and to celebrate this moment for survivors and advocates such as yourselves as the movement to end campus sexual violence once again has been championed by the White House, including President Biden, who has been a champion from the very beginning as one of the original authors of the Violence Against Women Act. I was also wanting to acknowledge how challenging the year has been for the movement and for your perseverance. Believe me, I know what it was like for you this last year, because it has been very hard for me too, not just this last year, frankly, the last 4. During the Obama-Biden administration, we issued the original guidance on Title IX to ensure that campuses and educational institutions were listening to and protecting survivors of sexual assault. We took painstaking steps to listen to all stakers who should have a voice in this process, from survivors to administrators, to parents and coaches, to fraternities and sororities, to academics who've been studying this field, to people in law enforcement, those who've been heading up our race crisis centers, everyone who was involved, because we realized there was no silver bullet. It was going to take an approach from everyone coming together and saying, not only do we need laws and procedures in place, but we have to change our culture. And that's what led to the original guidance. We wanted to make clear that sexual violence should not be tolerated any place, and that educational settings have a clear responsibility to protect students, and not doing so would be a clear violation of those students' civil rights. The March 8th executive order from President Biden directing the Department of Education to review the DeVos-era regulatory changes to Title IX builds on this important legacy began under the Obama-Biden administration. I was so pleased, as I am sure all of you are, to learn that last week, the Department of Education Office for Civil Rights is taking swift action to undo the harm of the last administration by centering the experiences of survivors and advocates in their review of the DeVos-era rule change, and having these experiences inform their future pathway towards reforming Title IX. I know that you're going to be hearing from our friends, Tracy and Kenyora, both of who are superstars and exceptional leaders, and more about what the executive order and the Department of Education's announcements mean, and how people will be able to engage in the Title IX rule and reform process. The more voices who are heard and participate in the process, the stronger the outcome will be. The federal regulatory process to undo the DeVos era regulations and replace them is going to be complex. But I trust that Tracy and Kenora will break it down for you and will support you wholeheartedly in engaging in the opportunity to inform the Department of Education in this effort. I cannot emphasize how important it is for your voices to be heard. Don't just take for granted that everyone's going to do the right thing. Your stories matter. The impact of the status quo on your lives matter. All of this is going to be very influential as we try to end sexual assault on college campuses nationwide. Here at Civic Nation, which I am proud to chair the board of, we will always be here to support students who come forward and survivors. We've seen so many incredible, brave survivors who have come forward and shared their stories with us over the years. And it's because of their bravery, truly, that we issued the guidance during the Obama administration, with Vice President Biden being one of the co-chairs of the task force that took a hard look at this issue. The Biden administration is listening to those voices, and we want to do everything possible to help in that process. And as President Obama said on the day that we launched, it's on us, a day I will remember forever. Survivors have been bearing this burden alone for far too long, and we're here to have their backs. And so we collectively as a country must continue to support survivors and let them know that we are here for them. Together, we will ensure that the Department of Education, once again, centers survivors' experiences in crafting the Title IX rule that protects survivors, their rights, and ensures that our campus is safe, our campuses are safe for all of our students. That's part of our responsibility in protecting their civil rights while they are in school. So I thank you for being here and for being willing to participate and for all of the work that you're doing across our country. It is so vitally important. We have to prevent sexual assault from happening. And when it does, we have to ensure the protection of the rights and that survivors' voices are heard. And we know with your collective effort, that will happen. So thank you, Kenora, for letting me pop on at the beginning of the call. I appreciate you and everyone on the call and all the hard work that you have done, and importantly, the hard work that lies ahead. Thank you, everyone.
Thank you, Valerie, so much for joining us today. We'll let you head off. I know you're very busy. Wow, thank you all so much for joining us today. And again, thank you, Ms. Jarrett, for your remarks. I'm so grateful that she was able to join us to share her thoughts with us today. And thank you, Kenora, for kicking off this virtual town hall. Again, welcome to everyone who has joined us today. I want to reiterate what both Kenora and Valerie said, that I hope you're all staying safe and healthy during this uncertain time. I know that there have been so many challenges over the past year, and I just hope everyone is staying as safe and healthy as possible. For those of you who I have not yet met on this call, I'm Tracy Vitters, the Executive Director of It's On Us. On the front end of my remarks, I want to say that the goal of this conversation is to help explain in plain language what has happened, what is currently happening, and what students can expect to happen in the future from the Department of Education Office for Civil Rights on Title IX reform. We recognize that the inner workings of the federal government are complex and often difficult to understand and navigate. We don't believe students should have to give themselves a crash course in civics or federal civil rights law to understand how they can meaningfully engage in the Title IX reform process as it's happening. So with that, I'll get started. To begin, I think it's really important for students to know that the DeVos era Title IX rule is still in effect. I understand that this is deeply upsetting and we all want to see it replaced. Unfortunately, though, because of the way that the DeVos Department of Education went about reforming Title IX, the current administration couldn't just simply wake up one morning and revoke the rule. For background, in 2011, the Obama-Biden administration and Department of Education issued guidance in what was called a Dear Colleague letter that clarified for colleges and universities, as well as K-12 schools, their responsibilities under Title IX to prevent and respond to incidents of campus sexual assault. This guidance also clarified for schools the standards departments would hold them to and what actions the Department of Education would take if schools failed to protect students from sexual assault and support them when they did report that it had occurred. In 2014, the Obama-Biden administration once again issued further guidance in the form of another Dear Colleague letter to address questions and concerns from college officials on the 2011 guidance. It was essentially a clarification document. And it's really important to know that what the Obama-Biden administration did was issue guidance as opposed to a rule change. Because this is why the Secretary of Education under the Trump administration, Betsy DeVos, was able to take swift action, essentially, to remove that guidance, but why it's also hard for us to just come in and sort of replace the rule as it exists now. So essentially, guidance is something that any federal department can issue to explain how existing laws and regulations, such as Title IX, are interpreted and applied by that department. Guidance can be used to explain new regulations that have come forward, respond to stakeholder questions about existing regulations or laws, help to clarify existing policies, or share leadership priorities and initiatives. It's also important to note that guidance is not legally binding. Agencies can also issue two different kinds of guidance: non-significant guidance and significant guidance. In the case of Title IX, the two Dear Colleague letters were considered significant guidance because they had broad and significant effects on the way that it addressed Title IX, which, again, as I mentioned, is a federal civil rights law. Unfortunately, though, because guidance is not legally binding, it was very easy for the DeVos Department of Education to repeal the 2011 and 2014 guidance in September of 2017. At that time, they issued vague interim guidance for what standard schools would be held to under Title IX by the DeVos Department of Education, and signaled that they would be escalating their efforts on Title IX reform to create new regulations, which are legally binding. The federal regulatory process on a law such as Title IX is not a simple one, and with good reason, because if an agency is going to fundamentally change how a law is applied and enforced, it must go through a rulemaking process. Now, for folks who were aware of and participated in the federal rulemaking process under the DeVos Department of Education, you know that this is a long and complex process. Again, as I said earlier, it's not something that they can just wake up one day and decide to issue a rule. First and foremost, the Department of Education had to draft the proposed rule change to Title IX and send it to the Office of Information and Regulatory Affairs, or known as OIRA. OIRA then reviewed the rule, which can include meetings with key stakeholders, both within and outside of the federal government, on the proposed rule change. So when, for example, the draft rule was put forward, It's On Us, EROC, other stakeholders in the field did set up meetings with OIRA to talk to them about the draft proposed rule change, because we were deeply concerned about what it meant for campus safety and student civil rights. However, once OIRA completed their review, the department did then move into an official Notice of Proposed Rulemaking Period, or NPRM, in November of 2018. Any department, including the Department of Education, is legally required to publish any proposed rule changes to a law and accept public comments on those changes. In the case of Title IX in 2018, the rule change was open for public comment for 60 days. And thanks to the efforts of advocacy organizations, survivors, and their allies, more than 125,000 public comments were submitted to the Federal Register, which, if you've seen it, is a very clunky government website. So it was a massive effort to get that many comments submitted to basically require the federal government to read and respond to them. Again, following the public comment period, any department that's participating in a federal regulatory rule change is required to read and respond to all unique comments that were submitted. Given that there were 125,000 comments, this took a lot of time. And unfortunately, though, despite the massive public opposition to the changes, The department did, as we all know, choose to move forward with the rule change with essentially little changes based off of people's concerns from the draft rule to what had initially been proposed. And as we know, the rule change did go into effect in August 2020. Because the Department of Education went through this federal regulatory process and did complete the rule change, the Biden administration, as I said earlier, cannot simply come in and revoke it. This is where President Biden's executive order from March 8th, 2021 comes into play. So on March 8th, President Biden issued an executive order directing the Department of Education to review both the DeVos era Title IX rule, as well as any related guidance, technical assistance, or other documents addressing issues of sexual harassment, including violence in educational institutions. Importantly, the executive order directs the department to complete this review process within 100 days. To start, the Department of Education responded by publishing a short blog post on their website stating that they would begin executing against the executive order immediately. Last Tuesday, the Department of Education announced, thankfully, the next steps that they would be taking to fulfill President Biden's executive order. Specifically, they announced 3 things that are really important for everyone to know. So first, they committed to hold a virtual public hearing with student survivors, advocacy organizations, administrators, parents, and any other stakeholder who wishes to participate to obtain feedback on the existing Title IX rule. The public hearing will take place virtually over the course of multiple days. The department stated that once scheduled, the dates for the virtual public hearing will be posted to their website as well as the Federal Register. For individuals who may not feel comfortable speaking as part of a public hearing or are unable to participate live due to various kinds of scheduling conflicts, the department stated that they will also be accepting written statements. Again, the way to submit the statements will be published on the Department of Education as well as Federal Register website. So once we have these dates and we have the ways for people to sign up for the public hearings or to submit statements, It's on Us and EROC will be sure to promote the ways that folks can participate in that. It's really critical that students and particularly survivors participate in the public hearings and or submit written statements to help the department understand the ways that they have been impacted by the DeVos Title IX rule change and what they would also like to see in a new rule. We really have an opportunity here to craft a Title IX that works for everyone and takes into account the needs of student survivors. Because we want to make sure that our campuses are safe and that sexual assault is a thing that rarely happens. And the way that we can do that is by making sure students and particularly survivor voices are centered as part of this process. It's also important to note that participating in the public hearing does not prohibit someone from also submitting a written statement. Both are permitted and encouraged by the department. Fundamentally, we want to work together with all of you to ensure that student survivor voices are heard throughout both the public hearing and statement submission processes. It is also very important that we have historically marginalized student populations participating, students who are students of color, who are LGBTQ, who are disabled, et cetera. Because fundamentally, if we build a Title IX rule that meets the needs of the most historically marginalized students, the rule will be better for everyone in the future. And that's what we all want. We want to make sure that that all student voices are represented as part of this process. Second, as part of the announcement last week, the department stated that they plan to issue a question and answer guidance document on the ineffective DeVos Title IX rule, with the goal of helping colleges and universities to understand where they have discretion in application of the existing rule, and in turn, do the least harm to student survivors and campus safety while the rule is still in effect. For those who might not be aware, the preamble to the existing Title IX rule is literally thousands of pages long, which has made it incredibly overwhelming for colleges and universities to interpret the rule, for student survivors to interpret the rule. And it's led to a lot of just confusion and misapplication, and schools also not knowing potentially where they have options for how they enforce the rule and when they have those things. So for example, under the rule, schools are given the option of choosing between a preponderance of evidence standard or a clear and convincing evidence standard when they adjudicate Title IX cases. We know that based off of evidence-based best practices, schools should be using the preponderance of evidence standard, as it does the most to support student survivors in achieving justice, and is the evidentiary standard for literally every other type of student misconduct investigation. And fundamentally, incidents of sexual misconduct should not be adjudicated differently than incidents of just say general assault, right, by a school. And frankly, schools should be required to have the same evidentiary standard and use the same evidentiary standard for all kinds of student misconduct. But unfortunately, the DeVos error rule gives them this choice. So, we expect that this kind of Q&A document will address those kinds of issues and help outline for schools, this is where you do have discretion. And we really hope that this Q&A document will help schools navigate the existing rule and do the least harm possible while it is still in effect. We also recognize that the department just sort of issued this rule change with very little technical assistance or additional guidance in how it's applied. And that has also created a lot of confusion for schools. And given the very short window that schools were given to enact this policy change, while they were also dealing with a global pandemic, while they were also dealing with issues of racial injustice and police brutality, that it was absurd for the Department of Education to think that schools in May of 2020 would be able to effectively change all of their rules and processes and procedures by August 2020. So our hope is really that this Q&A guidance document will allow us to help schools and will help the department help schools do the least harm when possible while this rule is still in effect. And then the third action that is last but certainly not least that happened last week was that the Department of Education stated that they anticipate that following the completion of the DeVos era Title IX rule review, that the department will move forward to issue a new notice of proposed rulemaking, or NPRM, to revoke and replace the rule. We anticipate a new rule will be put forward for a 60-day long public comment period, similar to the past rule change. And again, when the proposed rule change is put forward for public comment, it will be posted to the Federal Register website. It's on us, and EROC are currently exploring the various ways we can help students submit comments when the period opens, and we'll keep everyone updated on what our plans are, because we recognize, like, again, it's a very clunky website. The proposed rule that's put forward will likely be very legalese and technical. And so we will do our best effort to break down for you what a new proposed rule says and how you can support moving forward with that process, and making sure that we do get a Title IX rule that supports all students and all survivors on campus. We also, before I finish and we, take questions, I want to recognize that this process is long. And student survivors understandably feel a sense of urgency around the existing rule being replaced. I can assure you that based off of what I've seen in the conversations that I've had with the Department of Education, that they are moving as quickly as they possibly can under the restrictions and requirements that they have to meet to move this process forward. And so as we get more information on this rule change process, as we hear about opportunities to engage with public hearings through either live events or the written statements, it's on us, and EROC are here to help you navigate that and to make sure that your voices are heard. And so with that, we'd love to take questions from the audience. We know that I'm sure that there are a lot of them based off of just some of the incoming that we've had over the last couple of weeks. So if you have questions, feel free to drop them in the chat and we will do our best to answer as many of them as possible.
And Tracy, we also have someone whose hand is raised. So if you want to also ask your question live, we can do that as well. So let me see. The only thing is, if Adelina Morello, if you're able to ask she did right in the chat box. Thank you. And her question is, what education is done to teach men not to rape?
Um, so It's on Us, our core mission is to teach prevention education on college campuses with an emphasis on talking to young men about this issue. We think it's really important that young men understand healthy relationships, that they understand consent, that they are aware of what sexual assault is and what it looks like. And so if you are interested in learning more about our programs and the way that our It's on Us community chapter network works, please check out our website, itsonus.org. All of our prevention education tools are free to use. We don't believe that there should ever be a financial barrier to prevention education. And so we make all of our tools, videos, and other content free to any of our campus chapters or other folks who want to get involved with our work. We have about 300 campus chapters nationwide. Again, you can check out which schools have them on our website. And we also are in the process right now of re-registering existing campus chapters for the 2021-2022 school year, and accepting applications for new chapters in the coming for next school year. So again, we'll drop those links to either re-register a new chapter or to establish a new one in the chat box shortly.
And another question we have is, someone had asked, I believe, while you were sharing some information, is so DeVos's changes are legally binding, and this is why it's hard to change them. If you just want to reiterate that.
Correct. Yes. And essentially what happened is when the Biden administration did the Dear Colleague letter, again, that a Dear Colleague letter or guidance is something that is put forward. If it's significant guidance or not significant guidance, it is not technically legally binding. But a rule change to a federal regulation like Title IX is legally binding. And we actually have, I'll send over the link also in the chat box. We have a Title IX What's Happening page on the It's On Us website right now. And there it links to a document within that Q&A that explains the difference between guidance, regulations, how the federal rulemaking process participates.
And another question is, you mentioned that there were 3 important things to remember. What was the third and final point?
The third and final point was that we do anticipate that that following the completion of the DeVos era Title IX rule review, that the department will issue a new notice of proposed rulemaking to revoke and/or amend the existing rule, which is going to be really important. So that way students can have their voices heard as part of a new rulemaking process, and that we can show support for the parts of the new rule that we really, really like. And that if, I don't think that there will be things that we'll be completely opposed to, but if there are things that come forward in the new rule that we would like to see changed, that we are able to do that.
Another question is, thank you for the breakdown, very helpful. Currently, does Title IX have prevention education built into the policy? That always feels lacking at universities.
Mm-hmm. So Title IX has historically loosely addressed issues of prevention education. So the existing Title IX rule put forward by Secretary DeVos does not address prevention education. During the Obama-Biden administration, the Dear Colleague letters did reiterate for schools that they are required to do prevention education. However, it's not required under Title IX. It's required under the Clery Act. So for folks who maybe aren't as aware of the different kinds of laws that exist around campus sexual assault, there is a law called the Jean Clery Act, or just Clery as we all refer to it. Most people think of it as a crime statistics reporting law, which it is. Under the Clery Act, schools are required to publicly report to the government, as well as on their school websites, incidents of crime that occur on or near their campus. And there's specific geographic guidance on what is on or near campus, what kind, and there's also specific guidance on like how do you call something an act of sexual assault versus an act of just assault. And then there's different breakdowns, et cetera. But what's really important beyond just the data collection piece and the public publishing of the crime statistics is that the Clear Act was amended to actually require schools to provide ongoing prevention education on sexual assault and harassment. So sort of regardless of what's happening on the Title IX piece when it comes to reporting, survivor support, and adjudication, under the Clear Act, schools are still responsible for doing that ongoing prevention education. And we know it's been really challenging for schools to do that prevention education work, particularly this year with the COVID-19 pandemic happening and some students Zooming, some being on campus, some schools being fully open, partially open, et cetera. But technically and legally, schools are legally required to do prevention education with all students annually on their campus. And, unfortunately, though, we see schools sort of just doing one thing at the beginning of the year, checking the box, saying we did it. And we know that that's not the most effective way for addressing this issue. We really need ongoing prevention education and awareness throughout the school year that meets different student populations where they're at and has these conversations with them in a way that is relevant, which is really why It's On Us exists, is to make sure that students have access to ongoing prevention education, because we want to make sure that they are getting that education. They are aware of what sexual assault looks like. They know how to get consent. They know how to be an active bystander. They know how to support survivors when that happens. And we can also send out additional information on the Clery Act if that's helpful to folks, because we know that so much of the focus over the last decade has really been on Title IX. But the Clery Act provides a lot of support for student survivors, as well as folks who just care about ensuring campus safety and sexual assault prevention writ large.
Mhm. And another question we have, and thank you so much for providing that breakdown, Tracy. Another question we have is it possible that parts of the new regs will be changed or removed before the regulations are completely overhauled? For example, maybe some of the most egregious parts, like the definition of sexual assault or live cross-examination.
My understanding is that this is going to be like a total overhaul. And again, because the rule in its entirety is legally binding, it's difficult for the federal government to come in and say, like, in the short term, we're just going to remove this part. They can't legally, it's pretty difficult for them to do something like that, which is why the Department of Education has made the decision to issue that Q&A guidance document that I referenced earlier to help schools navigate the existing rule and help them understand where they may have discretion in application of the rule. My understanding is also that with that Q&A document, the department will be signaling how they will be enforcing the rule, and to what degree they'll be enforcing the existing rule and holding schools to that existing rule, sort of knowing, right, that the existing rule creates a lot of harm and actually tries to prevent campus sexual assault from being reported to them. So I suspect that we will see a lot more in that Q&A doc when it is published in the coming weeks.
Thank you. We have a question from a campus sexual assault specialist for TAASA, Texas State Sexual Assault Coalition. In 2019, their state passed two separate laws related to campus sexual assault. One is a mandatory report law for higher ed employees, and the other is a law similar to Obama-era regulations and guidance. Federal versus state is something that lots of our schools have questions. Can you offer some insights on that or speak to how these two may conflict and what impact it may have on students?
So this has been a very big problem nationwide, where we have states that are taking proactive efforts and measures to address incidents of campus sexual assault and support survivors. So Texas is one of them. Pennsylvania also has passed legislation over the last few years and is trying to pass additional legislation around survivor support and campus safety issues. We've seen our partners at Every Voice Coalition have been working to pass laws on the state level as well to support survivor rights and enhance campus safety. And so essentially what we've seen is schools will work with their general counsels to understand exactly where they have requirements by the federal government versus where they have requirements by the state. And if there are conflicts, how to address that. Typically, federal regulation trumps state regulation, but the states have been able to, in a lot of cases, navigate the existing Title IX regulations and say, yes, we aren't happy with X, Y, and Z part of the Title IX regulations. But what we are going to do is pass, for example, a survivor amnesty bill. So if a student survivor comes forward to report their sexual assault to their school and their Title IX office, while also having been underage drinking at the time of their assault, they won't be punished, right, or retaliated against by their school for that underage drinking that happened at the time of their assault. So we've also seen in Pennsylvania, for example, they passed a law requiring all schools to allow anonymous online reporting of incidents of sexual assault. Students who report through that don't have to go through a Title IX process if they don't want to. But the idea behind something like that anonymous reporting tool in Pennsylvania is to at least help schools during this really challenging period with Title IX, at least get an understanding of what incidents are happening, when they're happening, who they're happening to, even if students aren't coming forward with their name, class year, et cetera, but are at least able to give that information to the school. So that way the school can track that information, even if the incident that occurred is maybe not reportable, quote unquote, under the existing Title IX regulation.
Absolutely. And one question we have from our Facebook Live is, what about survivors who are currently affected on existing rules and Title IX errors?
This has come up daily. And, it breaks my heart that student survivors are having to navigate this existing process. And if you have specific questions about a specific case that a student is addressing, like, please reach out to EROC or to It's on Us. We're happy to talk with you and understand exactly what's happening. What we are working with some of our partners in the field on is collecting these stories right now of students who have tried to report or who have reported under the existing Title IX rule and the harm that reporting process has done to them. And also to see where misapplication of the rule has occurred. So, for example, a tactic that has been happening that we've seen since this DeVos rule has gone into effect is a student will come forward, they will report their incident of sexual assault to the school. The perpetrator is notified, and then that perpetrator reports them for some kind of student misconduct, whether it's an incident of, whether they're alleging that they were the victim in the sexual assault case, et cetera. But we've seen these like retaliatory filings happening with students, and that's really troublesome and should not be happening. But unfortunately, we are seeing schools sort of misapply the rule in that way, and it is a form of retaliation against that student survivor if a school then puts them under Title IX investigation through that process. And so, if you do have specific cases that you want to talk to us about, even if we aren't equipped to help you, we have a national network of advocacy organizations that also include attorneys who can help you navigate a specific case.
Thank you so much, Tracy. And I don't think I see anything else in terms of questions. If you do have any other questions, please feel free to drop them in the chat. I want to make sure I get to everyone here.
Looks like
I do see one. Does federal guidance, laws, policies for universities about Title IX carry over for K-12 schools, or are there any differences? Since the Clery Act clearly plays a big role in how colleges and universities prevent/respond to sexual assault, does that provide loopholes for K-12?
So for example, the existing Title IX rule that's in effect does apply to K-12 schools. However, there are specific modifications within the rule that are different for K-12 schools, because you are addressing typically incidents that include minor students. So there are throughout the rules, there are sort of like caveats for how it should be applied within a K-12 setting versus an institution of higher education. I think an example of that is the cross-examination piece. So for example, in the college post-secondary setting, if an incident of sexual assault goes to that adjudication process, there is a requirement for live cross-examination by the parties, by an advisor of the two parties' choices as part of that process. That is not something that is permissible in the K-12 setting. And they specifically call that out, that cross-examination is not permitted as part of that. So there's that piece of it. On the Clery Act, Clery Act by and large addresses colleges and universities. It is not something that is typically applied in a K-12 setting. However, different states have state laws typically around crime reporting. Again, in the K-12 setting, again, because you're dealing with issues that affect minors in the K-12 setting, there's typically a lot more liaising between law enforcement when an issue like this comes up, the parents of the students involved, and then the students themselves in the school. So in the K-12 setting, it's just very different. And oftentimes that's where state law comes into play around some of these regulations and protections, because you are dealing with students who are under 18 in most of those cases.
And I also want to go back to the former question regarding survivors who are currently affected by Title IX. For anyone who is also dealing with a current Title IX case, please feel free to reach out to EROC or It's on Us. We have partnerships with other agency advocacy organizations and attorneys who are able to help with students who are currently going through a Title IX investigation, whether that has been delayed, dismissed, whatever the case may be. Please feel free to reach out to us and we can connect you with some folks so that way they can answer your questions. And their services that they are able to provide are for free, where they're able to talk to a volunteer attorney about their Title IX case. So we'll share more information on contact below. So I want to make sure I get to everyone's questions as we're coming up on time. Another question we had, let me go back a bit, was I direct the Brandeis Feminist Sexual Ethics Project, which includes resources on sexual violence against various marginalized communities. I wrote a comment on the current regulations, but the DOE ignored all comments concerning disparate impact on students of color. And then thank you for providing that resource link. How can we all work together to get the new regulations to ensure safety for Black, African American, Indigenous, disabled, Jewish, etc. students? This needs to be a part of all trainings on campuses, of campus climate surveys, etc. And I'm happy to kind of answer this too, Tracy. Bernadette, first off, thank you so much for asking that question. A part of what NRAPE on Campus's framework is centered on centering the margins, and that is really to uplift and amplify the voices of historically marginalized and underserved student survivors in this space who are often left out of the national discourse, the conversation. And so we are actually working with It's on Us and other field partners to really collect survivor stories, especially those who are at the intersections of their identities with respect to the upcoming public hearing and the formal comment period that's also coming through the NPRM. So we'll be working together to actually collect exactly that, especially to make sure that we're bringing voice to those who are at the intersections of their identities. Because you're right, this definitely needs to be a part of trainings across and not just a part of our campus climate surveys, but even just a part of the trainings that we provide, which we do, but also with regard to what schools, colleges and universities are providing for their students. I think for the most part, a lot of folks are ignored and dismissed just due to, implicit biases and explicit biases, which is unfortunate. And so we have the opportunity now to really shift that narrative and bring those students' voices to the forefront, and really be heard and seen. And so we look forward to working with you. I've dropped some of our contact information in the chat to make sure that we can connect to discuss further on how we can do this together. Just on time check, we're at 1:21, which I believe we can take a few more questions. Let me see. I'm sorry if this was discussed already. It's something I've difficulty understanding and explain to student advocates. My previous Title IX coordinator would discuss it as a survivor stories are given 51% benefit of the doubt.
Okay, I can respond to that. So just to also respond to what Kenyora just talked about as well. So something I did want to call out, that President Biden's executive order does direct the Department of Education to account for the ways sexual harassment and sexual violence affects students differently based on the intersections of their identities, such as race, disability, sexuality, gender identity, etc. So the goal of that is to make sure that students who come from those historically marginalized backgrounds have a clear centered voice as part of this process. So we do anticipate that the Department of Education will want to be hearing from students of color, from LGBTQ students, from students with disabilities, from students who are historically marginalized in other ways. So I just wanted to call that out. On the 51%, my assumption is that you're talking about the preponderance of evidence standard. So on the second question, so under the Obama-Biden administration, schools were required to use a preponderance of evidence evidentiary standard when adjudicating an incident of campus sexual assault. So essentially, the preponderance of evidence means that you are more confident than not, or 51% sure that the incident of sexual assault did take place and that the student who was accused did perpetrate that incident, and that the schools then could basically use that evidentiary standard to then determine sort of what action then the school would take against that perpetrator moving forward. Under the existing Title IX rules I mentioned earlier, schools have the option to use that preponderance of evidence standard or a clear and convincing standard, whereas a clear and convincing standard is more aligned to sort of in a criminal justice system, a beyond a reasonable doubt would be sort of the equivalent within the criminal justice system. Fundamentally, every other kind of student misconduct, including other forms of violence that might occur on campus, are held to the preponderance of evidence standard. So whether it's an underage drinking offense, it's a fight that happens between two students at a party, it's a theft, etc. Those student misconduct violations are all held to a preponderance of evidence standard. But the DeVos Department of Education decided to give schools the ability to use a clear and convincing standard under Title IX for incidents of sexual misconduct, which again, like, sets a really bad standard that like somehow this incident is different from other kinds of student misconduct, and that fundamentally student survivors should have to meet a higher threshold of proof to be believed, which is really problematic when we know that the majority of incidents of campus sexual assault don't have other witnesses. They may not have a ton of physical proof, et cetera. And so a preponderance of evidence standard in a student misconduct violation investigation, which this is technically under Title IX, is a student misconduct violation investigation, should be held to the same standard as everyone else, as every other kind of misconduct. So preponderance of evidence. So that's that 51% piece. You're muted, Kenyora.
Sorry. One other question I do see is, what specifically do you see as damaging with the new Title IX rule that you want to change? This is a very loaded question.
I mean, all of it.
Right.
Kenyora would agree, all of it. Yeah, I mean, the Title IX rule, I think one of the most troubling pieces around the existing Title IX rule that I think a lot of folks aren't aware of because it happened many years ago and it sort of flew under the radar because it occurred in like the summertime, was in the summer of 2017, the Department of Education started to sort of covertly hold stakeholder meetings around Title IX and campus sexual assault. But those stakeholder meetings, quote unquote, were actually with men's rights activist groups, by and large, and other organizations that are very focused on essentially like undoing Title IX writ large, in the way that it does protect students. And it wasn't actually until somebody within the Department of Ed kind of blew the whistle that these meetings were happening, that student survivors and the organizations that advocate and support them were aware that this was even like that. It took that whistleblower to make anybody aware that these meetings were happening. And so once it became public that the Department of Education was having these kind of covert, quiet meetings with men's rights groups, did the advocacy movement say, hey, if you're meeting with these, men's rights groups, you also need to be meeting with student survivors. You need to be meeting with the advocacy organizations that support them and help uplift their voices, because fundamentally this rule change affects them. And so they did meet. They had one, I think it was an hour-long meeting with stakeholders. And one of the key groups in the field, who is one of our partner organizations, Know Your Nine, was uninvited from the meeting at the last minute because their co-founders wrote an op-ed about how basically screwed up this whole process was, and how it literally took this whistleblowing incident to happen for survivors to get even a brief amount of time with the Department of Education about this new rule change. So, fundamentally the entire rule change needs to be reviewed and revoked and replaced with something that is truly survivor centered, that truly enhances campus safety, that really does help colleges and universities support students in this really complex process and in this really traumatic process, right? No student goes to school saying, I can't wait to be 1 in 5 women who's sexually assaulted. That is not what people go to college for. That's not an experience that they want or should ever have. And it really is on schools to help protect their students from sexual assault in the first place. And when it does occur, uphold their rights, make sure that they have accommodations, make sure that they feel supported throughout that process, because it's traumatizing and it does disrupt a student's education. And to go through a Title IX process that then further re-traumatizes and harms them, that is unacceptable. And so we really do need a full replacement of the existing rule.
Absolutely. And as we're coming up on time, I just want us to move us forward in terms of a couple of calls to actions, which are really just simple, that I'm going to place in our chat box here. And that really is to sign up with us and learn more about what's to come, especially with regarding the public hearing that's coming up. Once we have more details on that, we would definitely want to share more on that. We'll definitely share out what the Q&A guidance will be, what that looks like, as well as how to get involved in the NPRM process. So you can visit our respective websites for more of that information and sign up to receive that as we receive that information ourselves. And we truly hope that you found this town hall very helpful. And I just want to give another thank you to Ms. Valerie Jarrett for joining us. And of course, my partner in this work, Tracy Vichers. Again, we just hope that this has been very helpful for you, and we'll definitely keep you abreast of everything that's happening with Title IX as more information comes to us in the coming weeks. So in the meantime, please take care of yourselves, and we hope you have a great rest of your afternoon. Thank you, everyone.
Thank you, everybody.